Welcome, everyone, to Surviving the Survivor. We're filling in for Joel, who's in Disney, waiting in line for a ride with his kids or waiting outside the bathroom for his kids. But with us today is Melissa from London. And we have Joe, who's in Sicily taking classes and being a tourist. And I'm here in Tallahassee working. So we're filling in. Today, Joel is not available, so this tripod of legal scholars is going to try to analyze, give a purview of what's happening with this latest motion to keep out Wendy's book in this case. So we're going to try to take your questions if they pop up, or we're going to give you analysis. And if you have questions, post them for free. We won't charge you. If they're good questions, we'll even consider them. If they're not, we'll ignore them. Just kidding. All questions will be considered. So, Joe, tell us how it is in Italy.
Right now, it's rainy and cold. Sunny Italy does not exist today.
Melissa, how's London? It's dark and it's what, 9 o'clock?
It is dark. It's almost 8 o'clock. We haven't changed time here. We will this weekend.
When do you change?
This weekend.
Oh, this
yes,
weekend.
Yes, okay. Italy. This weekend.
So Joe, have you seen the motion?
I have seen the motion, yes.
What do you think of the motion that was filed by the defense?
Well, it's short and sweet. And what I think about it is it's curious to me that they are pushing to keep the book out, and more curious that the state is really fighting it. Because I think the book is kind of icing on the cake in terms of motive, but I really don't think you need it. So it's interesting that they're, at odds about it, and they're willing to push about it on something that I don't think is all that critical. It suggests to me that maybe this is going to be more of a contentious trial than Charlie's was, in terms of the lawyers on each side.
Melissa, what's your observations on this motion by the defense?
Well, I think it's indicative more generally of this set of lawyers. So as the audience probably knows, it's a new lawyers for Donna. But what's interesting is this is another thing that has already been litigated, that Judge Everett has already ruled upon, that the new set of lawyers are going after yet again. And they have a right to do that to the extent that they think that they have something new to argue. But what's curious is how much is this going to annoy Judge Everett, because he's going over some of the same issues that he's ruled on again and again. So we'll see if they do have anything new today to argue about and what his reaction is. He could simply say, I rely upon my former ruling, or what could be quite a surprise is if he decides to overturn that prior ruling based on whatever new evidence that the defense has.
Yeah, it's interesting. The more and more they file these motions, you wonder if they're getting paid by the hour rather than a flat fee.
I thought that as well.
And you think that maybe the judge may reserve ruling, because Wendi is going to be a witness in this case again. And Donna more than likely is probably going to testify. So between Wendi on cross-examination and Donna on direct, they may open the door and make this book relevant, right?
Yeah.
So the judge may want to reserve.
Well, he already ruled that the state could not use it on direct with Wendi, but to the extent it was relevant to motive, she could use it to impeach. And at the prior hearing, what the defense lawyer said was they weren't clear. They didn't understand where the line was between what the state could do on impeachment and what not. And, Judge Everett said, what was so unclear about it? And that's why we're having this 35 to 45 minute hearing to sort of clarify what it means to be relevant to motive. It seems peculiar, doesn't it? But here we are.
Yeah, and it looks like the state's going to try to tie the motive to Wendi to Donna, right? Sure. Attach that motive to both of them. And so we'll see. I think You're right, Melissa. This might be the motion that will be the first victory for the defense in this case.
It could be.
It's curious to know. They got the motion to change venue coming up too.
Yeah, and that one's going to be that one is not going to be open. They've already agreed that that will be subject to a protective order. So it's curious to me as to what the defense will be arguing that they feel they can't argue in open court or they can't do on papers that are publicly available. But
well, what I thought was, remember they filed a motion earlier in this case, and they complained about it being publicly, and then they publicly contained the same articles that they complained about being in public.
Yeah,
maybe they learned from the judge that all this expert that's going to bring testimony about the community and maybe the jury veneer has been tainted. Why would we do that again in front of a potential jury panel watching it on TV at the pretrial motion?
Yeah. But it's still premature, isn't it? I mean,
yes,
you still have to see if you can sit the jury. So I don't know. I don't think this strategy, and Melissa talked about this a little. I don't think the strategy of bringing one thing after another, particularly things that have been ruled on when you really don't have anything new, is a particularly good strategy in front of the judge. And Tim, I don't know if you had a chance to hear the hearing the other day, but he was, to my ear, a little shorter, he was very polite, but he was, I thought, a little more abrupt, a little more, we're going to move on, let's go, than I've ever heard him before. And he is enormously sensitive to anything that comes within 10 miles of another conflict or another taint. I mean, it was
for a reason. Yeah.
About it. Yeah.
Yeah. Go ahead, Melissa. You were going to say something?
Oh, no, I was just confirming what Joe was saying is that again and again, for the conflict, that must have been extremely frustrating for him because he had tried to handle that many times before. That was another wrench in the works for all of us, making this case again quite interesting and complicated, and you never know what's going to happen. So what we're watching today is we're waiting to see if some other bombshell comes up.
Yeah, and with regard to that, Tim, they were pushing again with regard to the defense investigator to at least let the raw materials in, the photographs that the investigator took. So Judge Everett is going to look at that again. But he made a little speech about it. He does not want a conflict. And I know it's inconvenient to send your investigator out to take photographs again, but also doesn't sound to me as a monumental issue for the defense. So the strategy of continuing to push on things that he's decided, particularly things that hit close to the conflict issue where he's very sensitive and very prone to be prickly about it. It's just curious to me. Curious is the best word I have for it.
Yeah, these lawyers, sometimes you're right. Once you push too much, too often, you're crying wolf. The judge doesn't take you as credible, doesn't believe your motions are in good faith. They're just to antagonize and to belabor points and delay the case. Maybe Donna's asking them to do this. Maybe they felt Daniel didn't aggressively enough fight this stuff. But yeah, so I know people are waiting. We're waiting. I believe we're waiting for the live feed. And as soon as we get the live feed, we will go to the courtroom. And I'm hoping that the person in charge of the video understands we're waiting for that. We're not just here talking and having you look at us.
Well, but we have plenty to talk about. And Tim, I think your thought was right about it. Looks like this set of attorneys is billing everything they can because they are redoing a lot of what has already been done. And some of that would be absolutely legitimate. You shouldn't take the case that a prior attorney has developed. You should have some of your own spin. But the extent to which they are redoing so many things is interesting. So it does make me wonder as well as if there's a tap open in terms of the fees. But at the same time, it's also interesting in some occasions, this set of attorneys is arguing something different than the prior set of attorneys. And that's weird as well. For example, on that is a hearing I was rewatched from Rashbaum is he seemed to have conceded that the divorce was acrimonious, whereas this set of attorneys tried to downplay that and say, oh, no, it was just a normal divorce, no problem whatsoever. And those positions were quite different. And the latter, by the way, is the one that seems to be in conflict with the facts.
Yeah, it's funny. And, Jackie Fulford, the lawyer on the case, handled the estate, and the judge ruled there wasn't a conflict there. So this case has had so many twists and turns. Joe, you're right. The law about venue, you have to attempt to pick a jury and be unsuccessful in picking that jury before a court can even consider a change of venue. Now, unless they're just going to be laying the groundwork, and they got this expert that's going to come in and I guess bring in all the publicity, everything that's ever been on this case, and build a record, but it's still premature, the court can say, yeah, it doesn't matter if you heard about the case. The question is, can you put aside what you've heard and only base your verdict on what you hear in this courtroom?
Right.
And if you want to sit on that jury, you're going to say yes, and they're going to have a hard time proving it wouldn't to the jury panel.
Yeah. And Judge Everett has before said to them, I have to at least try to impanel a jury. And I think they can in Tallahassee. It's not that small of a place. There are plenty of people who won't know about this case. But you're something else you said before is I do wonder whether this set of attorneys, the reason that they're throwing all of this at the wall is just to see what sticks in terms of an appeal. It's almost as if they're already fatalistic about the result. And so they're just banking on something sticking with respect to a potential appellate point.
Well, if that's true, then it's one of the, let me rephrase this so I'm not mean. It is at least an example of them showing some good judgment about the likelihood of their likelihood of success at the trial.
So this is like a law school exam you get, right, Joe? Where the person regurgitates everything they know in the class, puts it in the answer, and hopes something sticks.
That's right. And I used to tell my classes all the time, the short answers, the short essays are typically the ones that show me that the person writing it knows what they're talking about. Yeah. I also wonder, Tim, you put it as they're running up the bill. And and if I put it a little differently, wonder whether they're just demonstrating to Donna that they're being aggressive and doing everything they can in her defense, because they're new to the case. They're not her lawyer of choice. They're not even the second round of lawyers that were on the case. And they may feel some need to show her that they're really good. They're aggressive. They're going to do everything on her behalf that is possible.
How do you think they believe she did in the hearing her bond hearing recently, for example? Do you think they actually believe she did well?
Do we believe that Donna did well?
No. Do you think her attorneys think she so that was, a preview for how Donna's going to do on the stand, and for some of the kind of the storyline that Donna is pitching in terms of, is anybody going to believe it? So the question kind of is, do you think they believe that she did well and they're confident in putting her on the stand again?
Looking at her testimony, I don't think she did great. I think she was a little emotional and like acting. I don't think the jury will come across and like her, but we'll see what happens when it comes to the regular trial. I thought the motions were poorly filed. You filed one motion claiming you wanted to suppress things that show she was fleeing. At the same time, you're filing a motion to get bond, and the judge has to hear that what you did in one thing would be terrible for your chances of winning the other motion, right? And he had them at the same time. So the timing was pretty bad. I think she had no chance getting a bond because of her ear canals. That was a farce.
Well, and I thought, to the extent that you assess, or I assess, her testimony, part of why I thought it was unpersuasive is because of the silly, in my view, silly argument they made in explanation of, her trying to leave the country. I mean, I can think of other ways to try to argue, but to say that in the face of evidence, which shows the frenzy that they were trying to get it done and finding, a place where there was no extradition and racing around wanting to get their affairs in order, and here are all the documents are, and buying a one-way ticket, and all of that, for her to say as explanation, well, we just wanted a vacation somewhere to get away and get some respite from all of this. It seemed to me, in some ways, a sillier argument than the one that Charlie made in defense, the double extortion theory. I mean, it just was, for me, silly. So it's hard to assess, for me, her testimony and how persuasive she was, because the argument was nonsensical.
Yeah, I think evidence at trial, and I know from information, she didn't buy the tickets. Okay, she had a third party, another person, buy the ticket, so it wasn't in her name.
Even better.
Yeah, so that doesn't show she was leaving for a peaceful junket. It looks like she was trying to hide the fact she thought they were watching her credit cards, so she didn't want to alert them she was buying the tickets. And
So,
that goes a
Tim-
long way to show she was untruthful.
Tim, as a trial lawyer, you're going to have to deal with it.
Right.
That seems to me the way they let her deal with it at that motion was silly. Of all options, which one would you have used instead?
On which one?
On, trying to explain away that she wasn't trying to flee.
That's a hard one because it's just a bad fact you can't get around. It was on the recording, so she can't really come up and try to explain it when she's sitting there talking about how she's trying to flee, and then she's trying to kick it out. It's interesting. It appears the hearing is on,
And we're not getting it.
but we're not getting it. Space Coast, are you there? Is there a reason why we're not getting the streaming of the show?
Maybe because he's not there. Does
They
not
say
appear
it's
to be.
on, but we don't seem to have it.
Well, it would be on. I don't know a hearing that Everett's done that hasn't been right on time.
Oh, he's just put in, he doesn't have a link. So we can continue to discuss while he tries to find it. By the way, Joe, aren't you in Italy? So if you're needed in the US, you can get back faster?
That's right. Well, I'm sure there's an extradition treaty here. So this is not the right place because they might throw me in a miserable jail here rather than just let me surrender to the marshals, whoever would come to accompany me back to the United States. Now, it's just, I don't know how you would explain it either. But it seems to me at least you might say we weren't trying to run because wasn't trying to run because I thought I was guilty. I was really upset. I thought I might be arrested because in my view, they railroaded my son. I mean, it's a bad argument, but it's got to be better than all I was doing was taking a vacation.
Yeah, she's going to have, that's the only argument she can make is I saw what they did to my son. He should have been found not guilty. I think once I saw the jury pool up there, I realized when Georgia said, hey, wait, see what's next, that I had to get out of town because they were going to railroad me too.
Right.
It's not because I'm guilty I fled, but it's because I couldn't get a fair trial. That's all they can argue.
But now she's going to be subject to impeachment because of what she said at the hearing.
Of course.
Under oath. So, I mean, they've made it worse.
Yeah, they lost the war and they lost the battle.
Okay. I just got a message saying they're trying to get us the feed.
Yeah, that's what they said.
Yeah.
So apparently Court TV doesn't have it. WCTV, our local news station, doesn't have it. So they say,
Okay,
Joe, let's hope if you're arrested, you can get a Band-Aid and your ear canals aren't too small.
I don't think my ear canals are a problem. And maybe I don't know enough about the jail. I know less than you two. I assume I can't bring in a little container of Band-Aids with me. I've got to rely on the jail.
Yeah.
Yeah, that's too bad.
So some reason, it sounds like Fancy Fiction and Mentor Lawyer is streaming it, and they got it from Pretty Lies and Alibi, but we don't seem to have it. So
Well, I'm sure Pretty Lies and Alibis would share. She's been very, very good.
share. She would share.
Yeah, it's been very interesting about the various podcasts covering this trial, about the cooperation between them. I applaud that. That's been very wonderful and transparent and friendly of them.
I think everybody comes in with the one thing they want. They want to see justice for Dan. They want to make sure the people who are responsible for what happened to Dan are prosecuted. And I know people are frustrated at the time it took and someone not being charged, but you just have to have faith the system will work. And you don't want to hype up what's going to happen if it doesn't happen. So someone have to be somewhat calm and cool in your predictions, what's going to happen.
Right.
But I think Donna is going to have a really hard time getting around the, consciousness of guilt. That instruction is going to be just so damaging to her when they put everything else before the jury.
Yeah. So Tim suggests that there's now, for some reason, Donna's current attorneys are conflicted out again, and you are appointed. Assume you would take the case. What would be your strategy on how to represent her? Sorry to put you on the spot.
Well,
you are a trial attorney. She's
done so many bad things. What we say in our business, we don't like to operate like a doctor on a patient that's half dead. You don't like a patient that's already cut open 9 different ways, and you have to walk into the emergency room and treat the person. We always like to get the patient from they come to for a consultation, and then you prepare it. I've been forced sometimes to do that, where you come in at the end, and it's not easy because you're not only developing your strategy, but sometimes your strategy is limited because of what they've done previous, and your client has said something or done something, or you submitted witnesses, and then you're kind of locked in. So you don't have the full arsenal that you would have in a trial. She's going to have to testify. Her only defense is going to be, I love my son. I love my daughter. Sure, I said some mean things, but I was so frustrated. I would never harm anybody. He told me that he was being blackmailed. I wanted to protect him, and I wanted to protect my family. I didn't feel it was comfortable to come forward. He assured me, and Dan assured me, that my son was going to be found not guilty. And when that didn't happen, my gosh, then I decided Harvey and I needed to go. And now we're here. I'm innocent. Charlie's innocent. And I'm begging for you to listen to the evidence. I mean, what else can you do?
So how do you, being in the area, think that she will be perceived by the potential jurors in Tallahassee?
Well, I always tell people that women judge other women much harsher than men do, and
that is true. And studies show that. Yep.
Well, now. That's one way to put it. The other way to put it might be that men are more gullible, particularly if it's particularly with an older woman or a pretty woman.
I've had cases where, like, a young college kid charged with like date rape, and they say, oh, you got to get all the guys on there. I don't want guys on there. I want the women, especially if I know that the girl did some things that make her look not so Vestal Virgin. Then the other women are going to judge. Well, the guys, they look at her and they might look at her like, hey, man, she's hot, man, that poor girl, and they might judge the guy harsher. It really depends on the kind of case you have. I think the jury's going to listen to the evidence. I think with the TV cameras, with all the notoriety, I think people go in there, and the way that jury selection and questioning is going to go, they all know this is a serious case. They all know they better report what they know if they have a conflict. And I think they'll get a fair trial. And I think I truly believe that.
Yeah, I do too, actually. I have a lot of faith in juries. I think they have a lot of common sense. And I think they come to a reasonable decision, probably certainly a great majority of the time. I don't think they go off on frolics and detours and, come to what we would say is a result that you can't explain. And I think they do try to take the job seriously, particularly in a murder trial where the result may be somebody's going to spend the rest of her life in prison. That's a pretty heavy responsibility to take on. I don't think they do it frivolously.
We are this community, because it's educated in college town. It's a pretty liberal community. The last election voted for Harris in this community. It's mostly Democratic, and so I don't know if there's any issues that really would lend over that would give her any extra benefit, right, Donna? Because really, no one wants anybody to be murdered. So I don't think it's not like the guy that shot and killed the insurance executive, right? Where you might have some people say, "Oh, they deserve that he's a martyr" and all that. I don't think that's going to spill over in Tallahassee in this case of a professor who was murdered.
And somebody who's going to be described by witnesses on the stand as a really loving and caring father.
Yeah, that's one of the amazing things too, is how much hatred they had for this man who just loved his son so much. We, often, or not often, but at times, sometimes fathers aren't that good to their children, and this one was so attached. And you would have thought that the children's mother and grandparents and uncles and all would have thought that was wonderful, even if they didn't like him personally. But then that seemed to be a reason for them to hate him more and want to plan to kill him. The sheer love of his children and how much he tried to take care of them.
Right.
But what's the possibility of jury nullification because they feel sorry for her and maybe they might empathize with wanting your grandchildren near?
So I'm getting the hearing. Okay, so I've got it. I've got it on my phone.
You can put it up to the camera maybe.
But I don't know how I can click it onto the show.
Oh, yeah.
You're getting it through Mentor Lawyers.
Somebody sent it to me, hearing.
Because apparently he's got it.
He's got it, and I believe.
Thanks to Mentor Lawyer for streaming that. It's the only place I could find it. It did sound like, it sounded like, that's right. It did sound like
some
judge was pretty much said his ruling, but was going to make it formal and pretty much said she can be impeached on that. And that's great. I'm highly enthused.
So
like the
Nancy
hearing's
Fiction,
over.
I guess, watched it. It may be over. Said the judge ordered, basically saying that she can be impeacched by the use of the book,
Which is
So
what
he
he
just
said
confirmed.
last ruling.
which is the
Exactly.
prior ruling, which
Right.
again is
Sorry, Tim, you didn't get your final win for the defense this time. That you project.
Well, she didn't get it,
not-
and I didn't think so. And under a 403 analysis, for people who don't understand that, we throw numbers out like we know them because we know it. But that's basically saying, is it more relevant or prejudicial? Is it relevant at all to the case? And is it more harmful or probative? The judge makes that decision. Most cases, they wait for the trial to make that decision. In this case, the judge ruled at least it's going to be admissible for impeachment. So he denied the motion. And here's Ileana.
Yeah, there she is.
Hi, everyone. We're in the car, so apologies if it gets a little loud.
Hey, Joel.
Well, thank you guys for thank you all for filling in. Sorry about the headache, but the ABC affiliate was a pool camera, and since there's a 4:00 newscast, they did not take it live, which they were supposed to. So we're gonna get it from the ABC station, and we will post it in its entirety.
Okay.
and I'm driving back. We're driving back. We survived 2 days at Disney and the Kennedy Center. So,
Congratulations.
Thank you. Thank you.
All right, thank you guys. We appreciate it. If you guys have any other comments, feel free. You guys can continue. I just wanted to hop in here because I couldn't flag you guys in the chat. But yeah, unfortunately, we were not able to pull it up live. But we will be sharing it with you guys, and I'm sure that at some point we'll be doing a full breakdown of it with probably this panel, since you guys are
Tomorrow, police interview. Wendy's police interview tomorrow.
tomorrow.
With film.
Okay, and tomorrow, Joel wants me to share that tomorrow
12:30.
at 12:30, he has Phil and Phil doing Wendi Adelson's police interview. I believe this is now
Part 3.
part 3. But I'm going to hop off of here. If you guys want to continue, feel free to. But just wanted to hop on and communicate and thank all of you guys and explain to STS Nation that we really did try to get this feed to you guys. But sometimes things happen, and with us being in the car, it got a little tricky.
Thank you.
Well, safe
Travel
driving.
safely.
All right, bye. Take care.
Bye.
And I will add with regard to Phil, looking at Wendy's interview the day that Dan was murdered, that they're doing a really good, very, very interesting job of breaking down that interview and talking about what occurred, what they would have done differently, and how they reacted to what Wendi said and her demeanor in saying it. So I think it's an interesting show, and if people here have a chance to see it, I would recommend it.
So are either of you writing a book on this?
Joel asked me to do it last week, and I said I really would think about it.
A book.
A
You
book,
could write a
yeah.
book about this case.
We certainly could.
And there are a lot of
Right.
players in this that probably would like to participate in this book.
Mhm.
This would be a really good seminar, criminal law seminar for upper level students about what to do, not to do, and how things change. And
You know, I found in teaching criminal law and criminal procedure that having clips of actual trials and what lawyers did and closing arguments and openings was much more instructive than any case they read or anything that
Yeah.
I said in a class, because they could see for themselves. And what's really, really helpful to law students is to watch a witness on the stand who tries to fight with cross-examination, tries to fight with the lawyer, and how ineffective that becomes, and how they look as though maybe they have something to hide as compared to a witness that just answers the questions as they come, how much more persuasive that latter witness is. And I don't know that law students could learn that or learn it well if they weren't able to see it. So one of the things that programs like this do is it's very helpful to law students in terms of training to be a litigator.
You know,
And
most
legal
trial
ethics.
teams and trial classes in school, they usually have the same people in the trial team act as a witness or act as a prosecutor.
Right.
So they're going along, they know a role. They're not being the agitated one. They're not being the hostile witness. They don't get that. And the trial lawyers that learn how to do that are the ones that have been burned by it. And you learn on the go, you learn what not to do. You learn when a hostile witness gets in the box, how to get in and get out. And sometimes you learn the hard way.
Yeah. And
Yeah,
this
Tim, have
case,
you-
go ahead. Sorry.
Oh, I was just going to ask Tim whether he'd ever been an adjunct teacher at FSU.
Have I? No, I've not. No, I have not.
You would be a great teacher.
You know, they let them know I've actually gone there, and I was a judge for a couple competitions.
Mhm.
And I've spoken to the classes there, and I've spoken at the University of Florida, my alma mater, but I've never taught at the school.
You
But I
should
would.
try. So, Joe, sorry, what were you going to say?
I was just saying, there's so much that's instructive about these trials for students, as I said, and I really think that to the extent that law professors can integrate, particularly in classes where it works, such as a criminal, certainly trial ad and classes like that, it works. But classes like criminal law, the more doctrinal classes as they're taught, the more that some of this can be integrated, I think the better a student gets to visualize what it's like to actually be a lawyer. And Tim, you're right. When you do the trial ad things, you get witnesses. Sometimes you tell the witness, be obstructive, but most of the time they don't have time to be doing that. You know, the students are learning the basics. You don't get to step 2. Now you've got an obstructive witness because they're learning how you handle a witness generally. But I do think it's the kind of thing we should be doing.
You know, it's interesting. In Florida, we have depositions. Some states don't have depositions. And, you know, I go into a deposition and I'm usually pretty fair and honest to just try to get what I want to get out. But then when you get that witness or that police officer that wants to lie and be a jerk, then I change my approach. I'm like, okay, we're going to go that route. Okay. If you want to do that, okay. Then you try to harness the person in. And it really benefits no one by them doing that. And the most effective witness is the one that answers the questions and admits wrongdoing. When a police officer goes, yeah, I probably could have done that. It's hard to hate that guy and hard to cross-examine him. Honesty is usually the best. But when witnesses try to make up or ad lib or cover, it clearly shows. And they don't come across.
What Wendi does, which is to quibble over words and to parse questions in ways that are just don't make any sense. Yeah,
because one of the very difficult things for witnesses to understand is at some points you need to concede the easy points, that you don't have to be right about everything, that you actually look more credible when you concede the weaknesses or that you were wrong before.
And you should never overstate, because you get caught on the overstatement. It makes you look like a liar, or at least somebody's trying to hide. And what happens is you distract from the nugget, the heart of the testimony that's important, where there is no, disagreement. Never overstate. It's just bad policy.
In this case, I was in Massachusetts during the summer when they had the Kieran Reed trial. And I did live coverage outside the courtroom during the verdict watch. And I will tell you, if people want to see good cross-examination and a case where it looks like there's things being hidden and witnesses are not being truthful and the evidence is not adding up, that's a great case for people to watch the Kieran Reed case. Because I think the expert testimony, the FBI and all the analysis, the phones, everything contradicts what the state believes happened in the case. And it's just alarming, some of the things that the state was trying to pass on as truthful. And the judge was pretty light with the state. And I thought the defense had a really good case. So I'm curious to see what happens on a retrial. The lead agent got fired. They fired him recently. So, but if you're looking for a trial to watch what's going to be a contentious trial, I don't believe this is going to be a contentious trial. I think it's going to just be Donna crying, saying you don't have enough. I didn't do anything. That's not what I call a contentious trial. That's just Pollyanna denying it, right?
So you think the defense lawyers are going to I don't want to say cooperate, but interact amicably with the state and not push and shove?
I think they will, but I don't think they're going to have a surprise witness that could undercut the whole case.
Okay.
Or a piece of evidence that really makes you think twice about the state's case. It's all, it's not direct evidence that they're going to have, but circumstantial evidence case, and her fleeing is, I think, enough.
Mm-hmm. You think Charlie will testify?
It'll be interesting. His lawyer, Michael, is more worried about the ineffective assistance than he is his client getting up there on the appeal.
Sure.
So.
Well, I don't know that we have anything more, and the hearing is over.
Right.
There are 7 new motions in limine that I think they said at the prior hearing that they're going to be raising. And they said they haven't, Tim, they said they have another motion to suppress.
Another motion to suppress.
Yes. And after they said that evening, I tried to figure out what they could be arguing that should be suppressed. And I didn't do a very good job of coming up with anything.
So Nan has a question here. Judge Everett said at the hearing that among other matters, Wendy's prior testimony can be used against her for impeachment purposes. So this is allowed under Florida law despite immunity. Well, that's two different questions. That's not really anytime. Melissa, you want to tackle that?
I'd have to go. The comments have gone way back, so I lost.
Okay, so they're saying the judge is ruling anything that Wendi said in trial in the past can be used to impeach her. Of course, we know that.
Right.
If you say something different at a different time, can be used to impeach. The immunity is clearly a separate answer. That immunity is against Donna, in case she is charged. They can't use that against her, but they could use it against her if she was charged and she testified differently. They might be able to argue that, that's a good question, actually.
What? Wendi?
She's got immunity, right? And she's
Right.
testified now.
Right.
Hypothetically, if Donna gets charged with the crime,
Donna
gets on
or
the stand
Wendi?
in her own trial and
Are you saying
testifies
Donna or
differently
Wendi,
than what
Tim?
she testified in these trials, could she be impeached by it, even though it was immunized testimony?
Yeah, I asked that early on. Forget who the lawyer was on, and I actually did some research on it to see what the answer should be. You've got the immunity, but you also, there's a very strong policy that you can't be protected if you lie on the stand. And so what you'd have in that case is two statements under oath, and they're contradictory, so one of them has to be wrong or at least suggests lying. And so the question is, which policy would override the immunity that you're given? But I think the immunity goes to your truthful testimony. You're not immunized if you lie on the stand.
Yeah, so I think if the prosecutor was smart, they would charge perjury also as a part of the indictment. So you can say, well, Judge, that goes to the second charge, not the count one, and it still comes in against count one. Isn't that devious? It's a little, but that's what prosecutors do. Melissa, what are your thoughts?
I think so too. Immunity and the impeachment are slightly different things. Also, as you indicated, is you're not immune by false testimony. A lot of people that are listening to this believe that anything that comes out, or if Wendi is talking, it's a lie coming out. So there's lots of opportunities there potentially to use some of her testimony against her. But in reality, I'm not sure they'll need to do that. The prosecution here is being very methodical, and I think they're continuing to try to gather evidence and information to use against Wendi, and we'll see whether they can against Harvey as well. And so luckily this is a case of murder, so there is no statute of immunity. They have as long as they want to. And the prosecutors are being cautious and methodical. What's interesting about today's hearing is the judge then again, relatively quickly, it seems, just reconfirmed his prior ruling. So we didn't see anything, or apparently there was nothing new, or at least significantly new to change. But they're going to continue on to file new ones. Now I have an overall question for both of you is, what could have been done differently to have prevented the conflict with Rashbaum?
Well, that's easy. They should never have let him represent or even get on Donna's case after he represented Charlie.
That's always a difficult thing, Melissa, in private practice. Sometimes you get calls, and sometimes you get a call and you won't get the big defendant call you first. You'll get the little ancillary defendant, and you really want the big defendant, or you get a call from the one person who wasn't charged, then the other gets charged and wants to hire you. You have to realize, hey, I got a conflict if that person testifies against. So I just don't think that Dan had the experience in private practice enough to realize the potential conflicts. And I also think that because of his relationship with Donna, he did things he probably wouldn't do normally. And like we all do things for our kids and our friends that we probably wouldn't do independently, someone we don't know. And that's what gets you in a box you can't get out of. And I think Dan was over his head. And I think
And
he wanted to represent her. And then he tried to go back and represent Donna, which was even crazier.
Yeah. And, underscoring all that, Tim, is everything you say about how close he was to her is a good reason for not representing her. I mean, you're too close. You can't be objective. Yeah, I it could have been solved had he never represented Donna. Had he ended with Charlie. Charlie would now not have an appealable issue with regard to the representation. And Donna would have been tried back in October. But you can't go back and redo history.
Right. I'm sure he would change things if he could now. He bowed out. He didn't make the court bow him out. At the end, he bowed out himself.
Oh, but that's true. But he didn't have any choice.
No.
Had he not done it when he did it, the judge
No.
would have done it 2 minutes later. So I don't know how much. This is a trial lawyer being kind to another trial lawyer, whereas the law professor just doesn't feel any compunction that way.
Well,
I do
I'm not,
feel sorry for him, but he had to bow out. Then he had no choice whatsoever.
the only reason I say that is because I've sat in that chair and I've seen things happen, and trials are fluid and people call. And I've had one time I was representing a defendant on a attempted murder case. And then I get a call and they're talking about a drug case. And I find out it was the victim of the attempted murder case. So now I've got attorney-client privilege with both, and I can't represent either one now.
Yeah.
I've conflicted myself out by accident, but I realized it quickly and called the bar, got the ethics hotline, and I withdrew and informed the court immediately is what you need to do. All lawyers should always contact the bar. They have the ethics opinion hotline, 1-800 number. They will walk you through it, and then you cover yourself.
But didn't Daniel Rashbaum tell Joel on that show where he was interviewed that he did consult on the potential of the conflict and whether he had to?
That does ring a bell.
That I don't know. I don't know how direct
He said
it
he
was.
contacted an ethics attorney.
Oh, not any.
He didn't say he contacted the Florida bar.
Different. You're right.
I can remember when I was taking the ethics part of the bar exam, the guided answer is whatever answer loses you money, that's what the answer is. Whatever you can do that you can't take the client, you lose money, that's what the answer is.
Yeah, but that, in practice, that can't be the right answer all the time.
Pretty much it is.
Yeah. Well, but you can, when you're absolutely safe, that's the kind of thing when lawyers advise newspapers or journalists that the absolutely safe answer is not a good public policy answer some of the time, at least some of the time.
Yeah.
But Daniel Rashbaum's situation was not inadvertent. It was at best bad judgment pushed by, as you say, Tim, too close a relationship to the family and particularly Donna.
Yeah. And there are conflicts that can be waived.
Right.
And there are some that can't be waived. I can tell you in my own practice, we have a form that we make them fill out, multi-representation, and we get them, each client, to sign it if we think there was a potential conflict, and we notify we're representing this person, we're representing this person. Should it become a conflict, you always have a right to get a separate lawyer. We always have that in writing. Dan never had any conflict in writing, which I was shocked when I heard that.
But he told
the
Joel
absence of
on
that.
that show that he did have it in writing, because I watched that program again, and Joel asked him, "You mean you got them all to stay in writing?" And he said, "Yes." Not accurate.
Right.
Yeah.
Well,
you can't
Melissa, what are you going to do tonight in London?
Well, it's coming up on 9 p.m.
No Broadway show?
Not for me tonight, no.
That's right. It's Thursday night there too, right? Yeah. All right.
Yeah, yes.
Well, I guess we've got through this, and
We did
didn't
an
even
hour
see the
without a
hearing.
hearing. Yes.
Imagine what we could have done if there was actually something to see and report on.
We would have just been interrupted in our wonderful chat
I guess that's true.
by a hearing.
Well,
But
I enjoyed talking to the two of you and
It's-
just, reacting to some of the things that have been happening. It was fun. A lot of fun for me.
yes, it was great being on with you, Melissa and Joe, as always. And I hope the audience got something beneficial out of this, other than seeing 3 people in 3 different locations. But thanks everybody, and I'm sure
Tim,
SBS.
thanks for hosting.
Yep, they voted me to host. All right, we're gonna sign
We
off
did.
now. Cheers till we see you
Thank
all
y'all.
again.
Bye.
Bye bye.
Yeah.